to indictment, trial, judgment, and punishment according to the law, end quote, id. In former President Trump's view, however, the word, quote, convicted, end quote, in the second phrase implicitly bestows immunity on presidents who are not convicted based on a negative implication. He asserts that the impeachment judgment clause, quote, presupposes, end quote, that a president is not criminally liable absent a conviction in the Senate. Appellant's Brief 12. Other courts have rejected this, quote, tortured, end quote, interpretation of the impeachment judgment clause, which previously has been advanced to support claims of judicial immunity. See Claiborne 727F 2D at 846, quote, according to Claiborne, this language means that a federal judge cannot be indicted and tried in an Article III court unless he has been removed from office by the impeachment process. Both Isaacs and Hastings rejected this tortured interpretation, end quote. Cleaned up. Hastings 681F2D at 710, Isaacs 493F2D at 1142. The impeachment judgment clause, quote, does not mean that a judge may not be indicted and tried without impeachment first, end quote. Moreover, former President Trump's interpretation runs counter to the text, structure, and purpose of the impeachment judgment clause. See NLRB versus SW Gen Inc. 580 U.S. 288-302, 2017. Quote, the force of any negative implication, depends on context, end quote, and, quote, applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded, end quote. Cleaned up. Mercy Hospital, Inc. versus Azar, 891F3D 1062 1069, DC Circuit, 2018, quote, finding the negative implication of a statute is a context-specific exercise, end quote. To begin, former President Trump's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant criminal immunity in the Constitution, as they did to legislators in the speech or debate clause. See U.S. Constitution Article 1, 6, Clause 1. Yet they chose not to include a similar